Regina. Good morning, good afternoon, good evening. Thank you for coming to the 12th Luohan Academy Frontier Dialogue. As Regina mentioned, today's topic is platform responsibility. We're honored to have 8 distinguished speakers today. All of them have done extensive research and policy work in this important area. I know many of you have thought about this topic. We'll welcome you to join the discussion. You can either enter your questions in the chat window or raise your hand at the end of each session. I have built in about 5 minutes Q&A after each session and another 15 minutes Q&A at the end of all sessions. If you have a burning clarification question during any presentation, you can raise your hand and I will do my best to include you. So let's start with the first session, which is about the shift in tone for digital platforms. Our first presenter is Professor Christopher Yo from University of Pennsylvania Law School. Professor Yo is one of the most cited scholars in administrative and regulatory law, as well as intellectual property. He is the founding director of the Center for Technology Innovation and Competition. Professor Yo, please take away.
Well, thank you very much. It is a pleasure to be here. As the sole lawyer in attendance, I am going to make a to accent the legal aspects of this, although for those of you who have engaged with me, my interests go beyond that, but we will start with this. And so, and in particular, there are many aspects about platforms, but particularly because I'm in dialogue with Marshall's paper, I'm really going to be focusing on issues around fake news, content moderation, and the like. Obviously, platforms raise far more issues. The other panels will discuss many of them, but in this sense, we'll talk about some of the constitutional constraints that happen, that apply. And as a basic overview to my talk, this is primarily about First Amendment limitations under the U.S. Constitution and how things will be handled under U.S. law. And to put the disclaimer on the bottom, my discussion is framed almost entirely by U.S. law because that is what I'm most familiar with. I have some awareness of some other regimes, but this is primarily a U.S. law discussion. And first, I'm going to talk about the First Amendment constraints on the government's ability to prohibit or mandate conduct. Second, we're going to consider different approaches to not just direct regulation, but imposing intermediary liability. That is, third-party liability, not for doing something wrong yourself, but facilitating someone else doing something wrong. And in fact, we have 2 different approaches under 2 different areas of law. Under defamation, we have one approach. Under copyright, we have a different approach. And we'll talk about how that works out and the constraints that surround that. And then I'll close with a brief comment about a current case that's pending before the Supreme Court that's actually scheduled to be argued on February 21, which is the first Supreme Court discussion of intermediary liability, the major statute on it on the defamation side, and talk about what many of us see as a potential distinction between intermediary liability for distribution and intermediary liability for amplifying speech, not just simply distributing it or making it available. So, without further ado, so if you understand, to look at the basic constraints or the basic case law under U.S. law on the government's ability to mandate or prohibit conduct, that is to correct for fake news, the first principle is the government is not allowed to restrict speech that is objectionable. So just a few classic examples: racial epithets, depictions of animal cruelty, different things. There's a violent video game example, things that people find to be low-value speech. The government is not allowed to be the arbiter of what is allowed to be said and what's not allowed to be said under the U.S. First Amendment. And this applies also to false speech. So there are a number of Supreme Court cases. There's one called Alvarez where a person claimed to have been in the military and received some very noted decorations, and they were all lies. There was a statute called the False Valor Act, which penalized that. It was declared unconstitutional, saying just because someone says something is false, we don't actually justify penalizing that. False speech about public figures. This is the famous New York Times versus Sullivan case. There's other cases, Brown versus Hartledge, where someone misrepresents something during a political campaign. And they said that the government is not allowed to actually restrict it because it's false. The other side is the government is not allowed to require an intermediary to provide balanced speech, to carry other speech in response to something that's perceived to be objectionable or incorrect. There's a case from 1974 called Miami Herald versus Tornillo, which struck down a statute requiring a right of reply when a newspaper endorses one candidate. The opponents had a right of reply under the statute, and that wasn't constitutional. And there's a case that's heading probably almost certainly to the Supreme Court next year on social media viewpoint neutrality. Florida and Texas both passed statutes saying that requiring there be non-discrimination, that all sides be brought out. One court, the Florida statute was held unconstitutional because this kind of balancing is not required. The Texas law was held constitutional, and we have a conflict that's almost certainly going to get resolved by the Supreme Court. But early indications from the Supreme Court on what they call the shadow docket, or their emotions about what do you do while you're waiting for the appeal to happen. The state of Texas requested that there be a stay, or the opponents requested that there be a stay, that the decision not be enforced until it's heard. And the Supreme Court basically signaled in granting the stay that's likely to follow the prior decisions of declaring this to be unconstitutional. And then we have a bunch of political speech cases, Buckley, Citizens United, that says the government is not allowed to correct political speech markets. So why is this the case? Well, there's a general sense that, and I'm quoting directly from a Supreme Court decision here, that private abuse exists, but correction by the state is riskier. The cure would be worse than the disease. There's a long legacy of thought behind this. John Milton's Areopagitica critiqued the British practice of requiring prior licenses before you published books, and involved in essentially amounted to state control of printing. And the belief is, he wrote a very eloquent complaint about this. And then somewhat later, that was in the 17th century. In the 19th century, Max Weber notes that the reason we are more suspicious is the state has a monopoly of the legal use of force. And there is the threats of exercise by the government are perceived to be riskier than by individuals. And there's also a part of this that is part of liberal theory, which says that people are subjects that create the state, not objects subject to engineering by the state. And this goes to social contract theory, whether it's Locke and Hobbes, and I really think of this in terms of Isaiah Berlin, that really thinks about the proper relationship here is that, in fact, the concern is always really summed up by Rousseau, is when you assume that people are suffering under some form of false consciousness, you can get some arbiter who knows better who can, to use Rousseau's phrase, force them to be free. And in a liberal theory idea, that inverts the idea. You can't force people to be free. By definition, that's up to them. And this is really encapsulated in the law by a dissent by Justice Louis Brandeis in 1927, is that the remedy to apply to false speech is more speech, not enforced silence. That is, the remedy to bad speech is more speech. And so the idea is not to restrict it or to put mandates on it, but rather to allow people to correct the record by opposing it and disagreeing with it. There are a number of exceptions to the rationale. Children exist because the minors are too young to decide for themselves, and we have more leeway. That isn't a blank check. Most notably, there's a case called Brown versus Entertainment Merchants Association, which struck down a California requirement that violent video games not be sold to minors without parents' consent. And they said that the record just doesn't justify that kind of restriction, even for children. And there is a broadcast, we see a lot more regulation in the US on broadcasting. It was justified by a rationale called the scarcity doctrine, which is now considered discredited because everything's scarce, not just broadcast spectrum. If you see the Supreme Court's reaction to it, it has been asked to extend it to other forms of communication, internet, cable, telephone, a long litany, and none of them, the Supreme Court has refused to extend it to all those doctrines. And then, in fact, a cautionary note, the experience under this doctrine was that it was politically manipulated for partisan purposes. Most notably, there's a wonderful book that looks at how the fairness doctrine was used during the 1960s by the Kennedy and Johnson administration to systematically suppress Republican speech. And so there's another level to this, which is the worry is any rules, they all can be gamed and almost certainly will be. So the assessment on this, Supreme Court decisions have adhered to a deontological approach to where really it's speaker-based, not really looking at effects-based. Exceptions don't really apply well to fake news, and that because fake news isn't about just about kids, and it isn't just about broadcasting. It's a more general problem. And there have been some calls from Justice Gorsuch, Justice Thomas, and noted scholars to change from this line, but there is not a clear, really any indication, and some pretty clear indications that that view remains in the minority and is unlikely to occur. All right. So talking about intermediary liability, there are two major regimes that govern this. One that governs defamation, one that governs copyright. Defamation is governed by a statute known as Section 230, which is a source of great publicity these days. And it sets up basically two forms of immunity, and it's kind of a misnomer because the word immunity is not actually used, but but effectively that's what it's easier to talk about it that way. One clause gives immunity if you simply distribute content and without editing it. So if you're a distributor, not a publisher, you actually are fine. And then there is a immunity for Good Samaritan actions taken on behalf of other people. That's for content that is obscene, filthy, excessively violent, harassing, and it's a list of terms. Even though you're exercising editorial discretion, you're allowed to take that kind of content down, this obscene, objectionable content, without losing immunity. And they considered and rejected whether you should set what we call a notice and takedown regime, which is a different approach, which is the one taken under copyright, is that liability, to maintain your immunity, you can post things, but if someone raises an objection, if you take it down right away upon notice that the speech is potentially illegal, you maintain your immunity. But if you don't necessarily do that. And in defamation, the courts rejected that it would lead people to take down too much speech. The concern would be is without actually considering whether the claim was valid, that the content was illegal, the intermediary would say, why run the risk? If there's even any claim, let's just take it down, without even looking at it, evaluating the truth of the claim. And that is sort of the concern, that we'd see an overabundance of speech being taken down. In copyright, you actually have a different regime, which is you have, under common law, a third-party liability regime which holds intermediaries liable if they induce infringement or profit from infringement while declining and exercising a right to stop it. There's also statutory immunity, as I said, for notice and takedown. And that's exactly opposite to what we saw in defamation. The rationale behind this is that a degree of immunity will promote hosting more content, and more speech is good. There's a rationale that applies less, which is these young industries needed the help. Notice and takedown also raises the concern that will lead to blind takedown of speech. And we see a difference here between defamation and copyright. You see, defamatory speech needs breathing room to survive. So even if it's actually technically not true, it needs to, unless you intentionally repeated a falsity, it's not illegal. But copyright speech is implicit in this distinction, is that's less problematic. I mean, so you lose some YouTube videos, that's less important than defamatory speech. We actually had to experiment in whether these rationales were justified. Well, first, the DMCA has engendered so many complaints that notice and takedown causes people to take down. People who don't even have a copyright in the speech will lodge a notice and it'll get taken down. And so it's flat out fraud. But what we saw in a 2018 amendment to Section 230 called SESTA and FOSTA, Congress withdrew immunity for sex trafficking content, and that what you saw is a wide number of intermediaries would take down all the content that even remotely resembled this. The most notorious one is Craigslist used to have a very popular personal section. They took it down because there was some danger there would be solicitations for prostitution embedded in them. And so you lost not just the speech that they targeted, but an broad range of speech around it. So expanding intermediary liability, there is something, that experience suggests that there may be something to reducing the amount of content. and that defamation and copyright are different. My last slide, we do have this burgeoning case in Gonzalez versus Google set for argument on February 21st. The facts are pretty heinous. There's a family of a person who's killed in Paris is suing YouTube, and there's this parallel suit against Twitter for recommending videos that recruited people to join the Islamic State. And the lower courts in this case consistently recognize Section 230 immunity. What's shaping up as the fight is whether, even if Google were immune, if it simply hosted the content on YouTube, does its act of extending, of recommending that through its engines to offering targeted recommendations go beyond that, go beyond mere hosting and going into amplification? And under the lingo we have here, at that point, they're no longer simply a distributor. They're now exercising some form of editorial control, not over the content, but actually of promoting it. In which case, I think that that's potentially a problem that would lead to liability. All right. That is all my comments. I hope that is helpful and sets off an interesting discussion with Marshall and with Geoffrey.
Thank you so much, Professor Yu, for educating us about U.S. laws. Our second presenter is Professor Marshall Valletti from Boston University Business School. He has co-authored a popular book titled Platform Revolution. His work on two-sided networks is a Harvard Business Review bestseller. He also holds patents on privacy protection and spam prevention methods. So Professor Valletti, please take away.
It's a pleasure, Ginger. Can everyone see the screen okay? I want to make sure that it's all visible.
Yes.
Excellent. Well, I want to thank Professor Yu for an excellent summary. I think a really fascinating set of issues surrounding intermediary liability. What I'd like to do is to give a couple of different results. The first of these is see about possibly redefining the problems in such a way that makes them somewhat easier to solve. It helps us come up with some design tools. The second is to actually show how it might be possible to intervene with intermediary liability to give it in such a way that we don't harm speech. So how is it we could be protective of First Amendment rights or speech rights generally, but also then hold platforms accountable for the damage that they cause? And the third is perhaps the hardest one of all. As Professor Yu pointed out, all the way back to Milton, I think it was in 1644, has been this problem of who should regulate speech? And usually there's some kind of central governance mechanism which is anathema to the regulation of speech. So is it possible to design decentralized mechanisms that would allow this to proceed? Could we create, if you would, markets in truth that are so totally decentralized, there's no single party, and therefore we would avoid some of the agency problems that we would normally have? One of my contentions is that we lack institutions to handle this because we have not recognized some of the externality issues in here. So I want to see if I can be clear about why I think that's the case, but let me take a quick look at what some of the current solutions to some of these intermediary liability problems have been. To the best of my knowledge, this is a summary of all of the different solutions out there, whether it's crowds or algorithms, media literacy, educating consumers, truth chasers and improved discovery, demoting the nude feed, banning, tagging and product labeling. Every single one of these suffers from at least one of the following problems. The technologies are all an arms race problem. The second one is that if some individual or group is deciding, then the liar simply discredits the decider. If you can lie about the content, you're happy to lie about whoever's deciding. The third, I think, is subtler. Most of these solutions put the responsibility either on the platform or on the reader or listener, rather than on the liar, when it's the liar who, of course, knows that the content is inauthentic and contains misinformation. So the responsibility is on the wrong foot. And the fourth one, which I believe is universal, not a single one of these solutions addresses the problem that it is cheaper to produce lies than it is to produce truth, that it is cheaper to produce stuff that you just make up than honest journalism. So none of those solutions work. I like to assert that the problem needs to be conceived somewhat differently. Most of this comes down to, it's not just the fakeness that matters. To give you a couple of quick examples, is Pluto a planet? Is it an asteroid? Well, it hasn't actually affected anyone's life. We've had various times thought the Earth was flat or that there were 6 planets versus 9. It hasn't really mattered. Another one, I like this particular restaurant, eat at Jay's and lives forever. Well, that's provably false, not only because you could check the science of it, but post-COVID, Jay's is out of business, so they must not have eaten enough of their own food. Another one is that fake news that is disbelieved just isn't a problem. So that's an issue. But there's plenty of occasions when true information does matter. When Russia used it to suppress black votes in the United States, or misleading half-truths that are used to create a lie. There are plenty of anti-vax groups that point out, here's a famous person, as Colin Powell, that took the vaccine and died of COVID, so that it must not have been effective, omitting the fact that he had blood cancer. So they use partial truths, so they combine them in ways that actually create lies. Or true news that's disbelieved can be a problem. At its heart, law, all law, whether it's Chinese or UK or American law, you can't own truth. You can't be dispossessed of truth. So in a sense, truth is not necessarily the great focus of law for mechanism design. What I assert is the issue, it's either decision error or externalities. If you look at the decision error externalities, you look at the loss of herd immunity from people not getting vaccinated, or pizza parlor shootings, or insurrections that are happening in the United States or in Brazil. You can be liable for decisions, and you can be liable for externalities. What this means is that this is why I think the problem has been so hard. Externalities cause market failures. Market failures require intervention, but government intervention is speech is expressly forbidden by the First Amendment. That makes this hard. That means that attempts by courts to turn this over to the marketplace of ideas will fail. The reason is markets do not self-correct market failures. The implications are there's too much pollution. People are not internalizing the harms, and so there's overproduction of misinformation. That is one of the reasons why we might see it so much since social networks had made everyone into a journalist, and they're not internalizing their pollution costs. And of course, there's now too little correction because attempts by courts to use marketplace of ideas don't work. And so the task is to internalize externalities and to decentralize intervention so that no one controls them. To the best of our knowledge, in economics, there are two and only two solutions to externality problems. They've been provided by Arthur Pigou and Ronald Coase. And so there are two different ways of looking at it. Let's see if we can examine both of them and see if we can actually use those as design tools for the externalities. Paul Romer has suggested possibly a progressive ad tax. The beauty of that is that it's not content-based. It's also shifting the business model towards subscriptions, which would reduce the invasions toward privacy. The challenge of that is because it's not content-based, it actually doesn't affect the nature of the harm. You could have a completely clean ad-driven system that paid a heavy tax and also a subscription. Imagine Parler was completely subscription-based, causing all kinds of harm. It's just not the nature of the harm. So Pigou would focus the tax on the externalities, and the way you could pass strict scrutiny, illegal would be to focus on illegal content, such as sex trafficking, incitement to violence, terrorist recruiting, or foreign election interference. Putin doesn't have a right to speak in, American or Brazilian or European elections. And so governments would have a genuine interest in backing that out. The other problems with these are twofold. The first is that if you hold platforms liable to this intermediary liability, the worry is exactly as Professor you just described, there might be taking down too much speech. So you'd be hurting speech. So that would be a problem. The second one is scale. It turns out if we're clever about it and we recognize it's a pollution problem, we can address both of those issues exactly. Let's show how we might possibly do that. The first of these is to recognize it as a pollution problem. We tackle this as a flow rate. You could hold platforms at intermediate liability at a flow rate. The way you do this is statistical sampling. Do you want 80% accuracy, 90% accuracy, 99.9999? You just take a bigger sample. It doesn't matter if you miss a few messages or you even get it wrong. You simply adjust your error bars based on the level of the flow rate and the size of the sample. And it easily adjusts to progressive rate. So you could have a pollution rate that's different for Facebook than for a startup. And this becomes a social dial that's easily weighted in different societies toward either greater information integrity or toward greater accuracy. Simply put, a doctor doesn't take all your blood to check cholesterol. He or she takes a statistically valid sample. We do the exact same thing here and hold the platforms liable simply for a sample. The second thing we do is we separate the original post from the amplified speech. Now, the interesting problem there is we've just addressed the scale problem. How is it that we hold the platforms accountable, but not hurt speech? Here's the issue. So the speaker provides the spark. This might be, something going on with the Bolsonaro election or the Trump stolen election. But then the platform provides the amplification. We just heard about the Gonzalez versus Google case, where the Google may be amplifying it. How do you hold one accountable without holding free speech accountable? What I want to do is to use the Shapley value. When you use a formula, we're going to separate the original from the amplification and show you what happens. So imagine the following scenario. A scientist creates an invention of value 1, and the venture capitalist amplifies it 1,000 times to build a business around it. The venture capitalist wants 1,000 over 1 plus 1,000th value of the share. Is that fair? Most people would say no. The Shapley value tells us what you want to do is to look at the indispensable party, and you give them their fair share of their indispensable portion of it. So for the first increment, the scientist is totally indispensable and the VC irrelevant. So they get 100% of the 1. For the second increment, 1,000, the scientist is indispensable and the VC is indispensable. So each gets half or 500. So the fair shares are 1 plus 500 over 1 plus 1,000 to the scientist and 500 over 1 plus 1,000 to the venture capitalist. So regardless of the amplification, it's easy to hold them accountable, whether it's a good or a bad. So if it's multiplication or amplification, 1,000-fold or 10,000-fold, or in Trump's case, 88 million-fold, it's quite easy to hold them accountable. But now let me show you a little bit of economic magic. Notice that the damage in this case is 1,001. Suppose that we hold the platform accountable just for its share, which is only slightly under half, 500 or 1 plus 1,000. Okay, what happens? If that's true, it becomes unprofitable and they stop amplifying. Because the damage was jointly created for 1,000 units, the full 1,000 disappears because the amplification disappears. What this means is you can leave up the original spark, the free speech, but you reduce the amplification. So long as you charge them at the ad price, lies become unprofitable to boost. And by the central limit theorem from statistics, this is highly predictable. So simply by charging the ad price for the pollution that we should hold them accountable for, you may be able to get a highly predictable tool that leaves the first post up and thwarts the amplification, so the 1,000 points of damage disappear. Let's turn to the second problem. And this is an ages-old problem. How would we design a Coasian market? What is the property right or the missing market, the social cost, and the essential nature of which is an intangible falsehood? I want to point out, by the way, these market designs are intended such that they could work in the US, in Europe, or in China. So these are not law dependent. What we want to do is to go down to fundamental rights to see if we could rearticulate them in an interesting way. So how would we design this missing market? How would we trade in the externality in a pollution cost sense? We have to ask what information rights would be and how they could be violated. We also ask, for example, there's a phrase that's been circulating ever since this Section 230 reformers come up. You might have a right to speak. You don't have necessarily a right to amplification, as an example. Well, think of your rights of information seeking and your rights of information speaking. Let us suppose that individuals have a right to gather information from preferred sources based on criteria of their own choosing. That gives them each the ability to see and hear what they want. Note that this right to choose asserts an equal right not to choose, and therefore a right to hear and a right not to hear. Importantly, the free exercise of that right could lead to balkanization and filter bubbles as people choose to hear only what they choose to believe. The speaker's right is simply a right to influence decisions that affect you. It also means, in a counter-speech sense, if some other speech is disagreeable, you have the right to provide speech that is agreeable, to influence decisions. But this entails being heard. Notice, at the extreme, the free exercise of this right can lead to lying and signal jamming as people seek private advantage, or something at the expense of others. This necessarily leads to a conflict of rights. How does the right to be heard balance the right to not be heard, right, or not hear in these things? If we combine two different branches of economics, not just externality economics, but information economics with externality economics, we might come up with what I would call a Spence-Coase market, signaling together with externality screening. So here's how it might work. Suppose that speakers are free to express themselves in any way they wish, facts or opinions, but a speaker gains a new right if they present facts. Notice facts are verifiable in ways that opinions are not. So a speaker gains a right to have factual claims heard, even over listener objection, by warranting that content is valid, meaning it is not illegal, so it doesn't pertain to sex trafficking, it's not incitement to violence, it's not stolen copyright, and it is not materially false. The election was stolen, vaccines have microchips, or the Pope endorsed my candidate. It's a time limit warrant such that, backed up by any resource. Either it could be social capital, such as followers or reputation points, or it could be financial capital, and it must scale with the externality. This is the Coasean portion. The speaker doesn't determine it. It's determined by the size of the externality. So a larger audience would have a larger externality associated with it. Notice anyone may challenge legality or falsity by paying peer jury adjudication costs. If the challenger wins, they keep the warrant. If the speaker wins, they keep the warrant. Notice opinions cannot be warranted, so they cannot be imposed on others without their consent. In effect, what this does is it defines two different entitlements. Speakers have a right to have true claims heard, even over the objection of listeners, subject to liability if they're wrong. Alternatively, you can do this as listeners have a right to be free of false claims, subject to liability protection. Let's show how this can reform US law, but I believe this could be applied to law anywhere. What's really interesting about this is if you look at laws in the United States.
1 minute.
We're going to run out of time, so I may run over by just a bit, Ginger. Thanks. So, United States, if you do a print ad, you're live. If you post lies in print, this is a 1914 ad, and this goes to the New York Times Solomon case. Print is liable for lies in their advertisements. Broadcast is similarly liable for ads in their advertisements, except for political candidate ads. The reason it was assumed is that because broadcast licenses are fixed by the state, you had to get approval. And so broadcast must take candidates' ads, but in exchange, they don't have liability. And then on the internet, Section 230, they have full discretion, but they're not liable at all. So we've got a full range on the far left where they're completely liable, on the far right, they're totally liable. And proposals have been to make them fair by introducing that legislation to reconcile it, perhaps on the broadcast standard. If you use this Spence-Coase model, you have a much better solution. Take a look at the Tom Steyer problem. He wanted to advertise on Fox News, and they simply said no because it contravened their editorial policy. Pillow Guy, Mike Lindell, wanted to advertise in MSNBC, and they said no because they didn't like him. If you use this Spence-Coase model, then it solves that problem. Tom Steyer could buy an ad on Fox. He simply has to warrant that it's true. Or Pillow Guy could buy an ad on MSNBC. He simply has to warrant that it's true, in which case you can get truth exposed to another audience, or you're liable for the falsehood. What the benefit is that this creates socially optimal liability. Who should be responsible? Well, it's not the listener. It's so grossly socially inefficient. The party that authored it knows if it's true or not, and it's socially efficient to have the platform check it once when they receive payment, as opposed to the users, there are 10,000 or a million of them, that don't receive payment. It's fair across all media. It puts the costs on the socially efficient party who can bear them, the least cost avoider. It maintains editorial discretion. except it gives the editorial discretion to the party with the liability. So it transfers the liability. In effect, it lets truth go up and polarization go down. You could use this for the Hunter Biden laptop story as a good illustration of this. Most of you may know that Hunter Biden, New York Post published a story claiming that Hunter Biden had dropped off these laptops, water-damaged laptops, at a blind Trump supporter repairman, and then never picked them up again. Then his personal emails and pictures made it to Steve Bannon, and from there into the New York Post. Interestingly enough, one of the co-authors of the story didn't think it was credible and wouldn't put his name on it. You could use it. Now the conservatives are complaining that they've been suppressed when Twitter and Facebook didn't do it, but didn't disseminate it. But what's interesting is, if New York Post thought it was credible, they simply have to warrant it, and then it could be spread. If they aren't warranting it, then Twitter and Facebook don't have to choose to spread it. Others don't have to listen to it. What's really interesting is, if they won't warrant it, then they don't believe it. And if they do warrant it, even Hunter Biden could challenge it and then uncover the private information. So it effectively solves the problem of decentralized adjudication of truth, and the party with the liability is the party in the best position to bear responsibility. We're running out of time, so I won't go through the full benefits of it, but this changes the cost structure problem because it makes lies more expensive than truth. It solves the arms race problem because it's not a technological solution, it's a human behavior problem. It puts responsibility on the least cost avoider, and it internalizes the externalities. Anyone can challenge it. In this case, it's not just New York Post to voters. Hunter Biden, who might have suffered the externality, could challenge it, or anybody party. So it transfers the externality to the liar. It solves the discrediting the raider problem. And most importantly of all, it is a totally decentralized market mechanism that has no single party that adjudicates truth. So it's a mechanism of combining information economics with externality economics in a way that could be applied perhaps in any marketplace as a way of trying to go after this particular problem. For those that are interested, the paper is just available at the address below. It's Free Speech Platforms and the Fake News Problem. And with that, I would love to hear any commentary because it's just a first draft. Looking forward to submitting it. So hope to hear your thoughts. Thank you.
Thank you, Marshall, for sharing so many provocative thoughts. Our discussant will be Professor Geoffrey Parker from Dartmouth College. Professor Parker is a chair professor of engineering innovation. It's quite a cool title. In addition to co-authoring with Marshall on the popular book Platform Revolution, Professor Parker has written extensively about platform business strategy and ecosystems. Geoffrey, take it away.
Ginger, do you see the full screen or the presenter view?
I see the full screen.
Great. Okay, so I yielded some time, so this is going to be short. And honestly, discussing this many ideas in 10 minutes is a little silly. So I think what I'm going to do is kind of reiterate what I think some of the really critical points, and Dr. Yu did a great job of setting that up. With the caveat of this being a US-centric analysis, and we have people, Jacques, Tommaso, who can kind of speak to the European context, but I'll do so a little bit. This issue in the US of the First Amendment restricting, sort of doing prior restraint or being an arbiter of truth is, of course, one of the fundamental problems that you know, Dr. Yu pointed out, and then Marshall is trying to solve for. I did think that it was interesting, and maybe Dr. Yu and I saw that slightly different. I thought it was pretty impressive that the Craigslist kind of trafficking pollution, if you will, was something that could be thwarted, as opposed to seeing that as a real problem. So I thought that was a space for some innovation. I think this is a very important distinction that both of our presenters raised between distribution and redistribution or amplification in the terminology they used. The economics, Dr. Van Alstyne pointed out the cost structure of production of fake news may be more cheaper rather than truth. But I think an equally important point is the work that Sunan Aral did with co-authors, noting that the novelty of fake news is often more engaging. And if you combine that with the business models of an ad-sponsored, multi-sided platform, you then create really strong incentives to distribute false information. And so that's, I think, one of those business models are at the heart of what need to be solved for. In Dr. Van Alstyne's paper, he points this out, and I think, Dr. Yu alluded to it, but I think it's worth saying this is a really big problem. We've got demonstrable evidence of kind of excess deaths of COVID as a result of fake information, well-documented incidents of election interference across the world, and not just in countries like the US, but often in sort of medium and smaller countries where autocratic regimes are able to influence election outcomes using social media campaigns. An earlier version of sort of the harm actually came out of radio, sort of a precursor, if you will, to our platforms in the 1994 Rwanda kind of massacres. And then more recently in Myanmar, where Facebook is under fire for amplifying false claims about the Rohingya, and then that's led to violence against a specific population. And then near and dear to my own heart, one of my undergraduate college classmates is Dr. Maria Reza, and she's people probably know, but she's a journalist in the Philippines and has been under significant kind of fire from the Filipino government. And that's much fake information. So, a lot of problems here and a lot of need for solutions. So I think from this group, we're really good at identifying the problems. I think we've got a lot more solution needs. And so if you look a little bit, I think the EU is worth pointing out as a place of a lot of ferment, if you will, for policy innovation. And kind of full disclosure, Tommaso, Marshall, and I spent a fair bit of time looking at the Digital Markets Act as part of a project for commentary for the European Union. But they've done some work on the Digital Media Observatory, implementing rapid alert systems for detection, commitments from the technology firms, and a code of practice that was just updated recently, a couple months ago, on disinformation. The problem here is on the last bullet, which is that this is all voluntary. And so you've got space for innovation, sort of Sweden versus Hungary, but you've also got a lot of leeway. And so when we've seen that, it's hard to make progress. And so that's why I'll kind of finish on why I like what Marshall's doing, which is to try to take this utilitarian view where we've seen prior deontological views, based on the speakers, and then have this distinction between distribution versus amplification, and then assign where the harm comes from. Of course, we've already seen in chat, and it's one that Dr. Van Alstyne and I are already talking about. The devil's always in the details in this, because you've got to think about who can determine truth. How do you actually crowdsource enough of this, and who's the ultimate backstop? Because at the end, you'll have to have some authority. You can't just, unless we're going to believe in sort of the Neil Stephenson snow crash world, we're going to have some sort of a backstop on the market, on the claims of resources, on something. That being said, I think this EU kind of focus on gatekeeper platforms and then a lot of state level experimentation offers some hope for just a distributed set of efforts to see kind of what works and what doesn't. With that, I'll turn it back to you, Ginger.
Thank you, Geoffrey. I see some chat window discussion on who will arbitrate the truth. Seems like Professor Yo and Valletti have responded. So we can keep on discussing in the chat window, but in the interest of time, I want to move to section 2. Let's learn how the business practice have evolved on the responsibility issues. So our first presenter is Dr. Chen, who is the president of Luohan Academy. Before joining Luohan, he was a professor of finance at Washington University at St. Louis, associate dean of Changong Graduate School of Business, as well as the chief strategy officer for Ant Financial Group. So Long, please take away.
Okay, so can you see my slides? You
Yes.
can hear. Okay, cool. Yeah, so so good evening, good morning. Let me change the angle a little bit to talk about the platform responsibility. And so since we're talking about platforms, so I'd like to discuss a little bit what is a platform. Now, there are actually many types of platforms. Some of them are just a simple matching, producers and the consumers, buyers, sellers, etc. Some of them, like Amazon or in China, TJ.com, it's more like a mix of the both. They are actually a retailer. So they buy stuff, they sell stuff themselves, but in the meantime, they also provide the platforms for third parties. Another type is it's like Apple. I call this it's like a T-shape. So Apple is a producer of the electronic products, iPhones, etc. But on Apple, you have the Apple Store that connects the buyers and sellers. So it's partly a firm. It's partly a platform. So my point is that there are many of them. But whenever we talk about the platform, it is different from a firm in the sense that it engages multiple stakeholders, and then nobody actually owns the whole thing. So the platform provides values by actually lowering the cost of interaction and transaction between the multiple stakeholders. It also provides the necessary infrastructures and some of the so-called design attributes Olive Hart and Roberts mentioned earlier. But they mentioned this, what is necessary to be combined, ingredients to be combined within a firm. But now we see that on the platforms, a lot of functions combined together. Let me give you one example. So on Alibaba's Taobao, so there's many 10 million SMEs. So there's more than a billion consumers. Now it's not just matching them, but actually the platforms also work with the third parties to provide the API capacities, payment, logistic, computing power, etc. That makes every stakeholder on it, every SME on it to possess the power that usually only belongs to the big companies. And because of that, it is, I would say, this is ecosystem of the multiple stakeholders, and it goes much beyond the traditional scope and the boundary of the firm. So that's my first point. Now, so viewing platform in this way then, so we can think about some of the principles probably might be useful. The first principle I would like to say is that probably, so whenever we think about the responsibility, because it's a coordinated value system that doesn't belong to a single stakeholder. So when we think about the responsibility of a platform, we need to think about how the value is created. Because simply assign the responsibility to a single stakeholder, including the platform operator, that can probably jeopardize the value of the whole platform. So that's the first thing. We need to understand how platform works before you think about how to assign them a responsibility mechanism. Now, the second principle is that probably most important is that we shouldn't take a platform as a traditional firm. In a traditional firm, we actually know who owns the firm and who controls the firm. So as we assign the proper responsibilities. But for a platform, it's not even a broadcast station. For platform, actually, because no single stakeholder owns it. So you need to, the value is created in a coordinated way. Probably responsibility should be assigned in such a way too. Otherwise, it's not very effective just by using the traditional ownership and control approach. Now, the third principle I'm trying to say here is that probably we want to think about the efficiency of a platform. So when we think about and I think Marshall and previous speakers talk about this issue. So we have to find an efficient and fair way to do this. For one critical issue, for example, is how much should regulators step in? And so I think following Marshall's point, I would think that for externalities that platforms cannot resolve by itself, regulators and policy should step in. But there's a bunch of issues because as it's a coordinated this ecosystem. Actually, it is to the benefits to many of the stakeholders actually to show the required responsibility if it can resolve the externality by itself. So there's a bunch of things that can be done left to the market to find its solution. Another issue we can think about is ex ante and ex post efficiency, and how much ex ante responsibility you want in place to the platform or the operator or some stakeholder. Some of that should be just implemented ex post. And that also has a lot to do with the efficiency, because if there's too much ex ante requirement, it might kill this whole platform activity, as we can see from some of the current real life examples. Now, that being said, I'm going to apply the simple principle, some proposal, to some of the issues people talk about a lot. The first is the product service content risk. Now, so I think right now that some of the approach is to apply the detection and enforcement approach. So, for example, in the EU's Digital Service Act and in China's guidance for the platform responsibility, it's for the GPR. It says that internet platform operators shall verify and register relevant subject information of operations for applies to enter the platform. So anyway, so some of the stuff you need to detect. And also you should develop the infrastructure to enable the stakeholders to fulfill their responsibilities. So as you can see, this is approach. This is approach that actually has some requirement, but it doesn't ask for the full responsibility as a platform operator to do things. So that's a combination of the policy requirement and some of the engagement of the stakeholders, including both the operator and the participants. And also the enforcement part, it also requires you have the system that can handle the internal complaint handling or have dispute settlement system. So that is the coordinated approach. Now, so here, for example, give me some example for Alibaba's Taobao platform. It has the procedure to identify the detection measures, including the product standards and certificates requirement, quality monitoring, random check, but it also have the quality flags enforcement and stuff like that. Now, as another good example, this example, it provides the platforms it provides the consumers reviews, consumers queries, and consumer returns. All those information makes it transparent. So it is the participants of a lot of stakeholders, and with the mechanism that makes the shared responsibility such that it helps the sellers know the quality issues, helps the platform to enforce the punishment on the product sellers. It also resolves some of the conflicts. And sometimes when the conflicts cannot be resolved, it has the online courts that actually randomly assigned by the stakeholders to solve this kind of issues. So this again is a coordinated approach to share the responsibility to make sure that the platform is trustworthy and it can be functional. Another good example is the data privacy. Obviously, data privacy is crucial to the users, to the consumers. But in the meantime, data exchange and flow is actually essential for sharing the opportunities, serve the customers well. Now, and it's very difficult for the stakeholders, individual stakeholders, to have the incentive to really protect just the privacies. And so in this sense, I think the current approach, we can see that it's the government provides the guidance, the laws, the guidance for the privacy protection. In the meantime, we can see the platforms across the world. We see in the United States, also in China too, we come up with a lot of the so-called privacy enhancement technology and mechanisms actually to enhance the data flows between the business, consumers, and in the meantime can protect the privacy. How can this be done? Well, the so-called PETs, privacy enhancement technology, it can either create a secure environment such that data can be shared without being abused and to be circulated, or it generates safe data by masking or encryption to use or share. So that's using the technology that much reduce the trade-off between the privacy and the data sharing. And so it has been implemented a lot in the practice across world recently. And this is a very good example of combining the policy, the laws restrictions with the technology and the mechanisms with the market participants, because overall, in the end, they do have the incentive to make this function. Now, and so as one example, as in Taobao's, last year we rolled out the order phone number protection, for example, because you see, in order to serve the consumers well, a lot of involving parties, they need to know the details about the consumers, but then you cannot restrict them using the details. Now it's becomes general that you all use the digital virtual numbers, although to make this whole thing works, and that will expire, but you don't circulate the original properly privacy related information anymore. So it's pretty much covers most of the consumers nowadays. This is a very good example, and I think it's being widely used globally. And also in China, if you look at the progress of the data privacy and security of the regulations, also very interesting, because in the first stage, it promotes the protection of the consumer privacy and the data security through the laws passed, several crucial laws. But then a very important policy has been just released in December of last year. It's called the 20 measures to build basic systems for data. Essentially, it actually established a set of data rights for the rights to collecting, preserving, using, and using the data products. They're separate. They're separate from ownership, because it's very hard to have a single ownership for the data because of the non-rivalry nature of the data. So it properly defines all different types. It actually encourages the production and the exchange of data. In the meantime, it also has the clear restrictions on the circulation of the privacy-related data, stuff like that. So that's you can see the progress. And this is another typical issue that I think the responsibility is shared by the regulations and also the platform or stakeholders. You have technology and mechanisms to make this work. Now, another good example people debate a lot is the gig workers. Of course, the gig workers, it gives them the flexibility of the work opportunities, but in the meantime, they also probably have limited benefits. So who should be responsible for those gig workers? Now, we're going to see that there's actually a variety of the policies, and there's different value systems regarding the boundary of these things. How do you solve these problems? So I'm going to give you some particular examples. For example, in China, two major gig worker platforms, Luohan and Meituan, and they have two types of delivery workers. One is called the 专送, so they are the full-time employees of a third-party delivery service provider. Now, those laws, they are subject to requirements on the work out times and exclusivity requirements, compensation, etc. So they are entitled to employment benefits. And there's another, it's another type of drivers that are much more flexible with time, location, and they have no exclusivity requirements. And so they are treated as the independent contractor. So that's what's doing right now in China. But if you compare the US and the EU, they're quite different. The US right now, they actually last year, October, they have this 6-factor economic reality test. The 6-factor to decide, is it independent contractor or not? And it needs to collectively think about those 6 factors, but I don't have time to elaborate on this. But if you look at EU's, it only needs to satisfy 2 out of the following of 5 criteria. And so, for example, if the platform determines the pay, it requires workers working regarding the appearance, conduct, work clients, performance of work, or the platform can use electronic means to supervise and assess the work, and it restricts the time and the freedom or the exclusivity or non-competition issues. But my point here is that I think China's right now the requirement is not going to pass the EU test for now. So my point is that you can see that the different lawmakers actually have different requirement here. And so the key is what is the most efficient and how to make this work. When we think about responsibility, we need to think about those principal issues. Now,
1 minute.
Okay, I think I need to be faster. What is this here? So another thing is the gatekeeper. This is another discussion people talk about a lot. Now, the key, of course, is gatekeeping for what, to what extent. That is, there's a difference. And for the EU, it used the Digital Markets Act to complement existing competition laws to make it faster to have the required ex-ante obligations. US is a bit slower, but in some way, but China also have this gatekeeper nature in some of the stuff, but they actually, there's a trade-off regarding what they believe regarding the principles, how it works. If you look at, for example, how do you design the large platforms, EU's, if you compare the EU with the US tends to be like 10 times bigger than the EU. So what is the large platform? So the definition is different. And also which kind of things should be ex-ante gatekeepers should do? Is it correct for the self-preference, to be fair, to force the interoperability, or it's just that you are forbidden to do some of the self-owned business stuff? Like they can see that there's a difference. And I think I'm up. My time is up. Let me summarize. But I guess my key point here to remind the audience here is that a platform is different from a firm. So we shouldn't just simply apply what we're familiar with a firm, the ownership, the control stuff, then assign the responsibility. Here, a platform we need to understand how it functions, why it is not a firm. It's collective, it's cooperation to create value. In this sense, then we also need to assign responsibilities that is in a coordinated way. They have to share responsibilities. We also need to think about the efficiency of those this responsibility sharing mechanisms, including ex-ante versus ex-post, including how much the government regulations functions and how much it needs to leave to the market to find such a solution. Let me stop here. Thank you.
Thank you, Long, for sharing these interesting examples and different practices around the globe. Our second presenter is Professor Mike Luca from Harvard Business School. Mike has done extensive work on the design of online platforms and on helping organizations to leverage data to inform managerial and policy decisions. He has co-authored a popular book titled The Power of Experiments, Decision-Making in the Data-Driven World. Mike, take it away.
Thanks, Ginger, and thanks, everybody. I'm excited about this discussion. Today I was going to talk a little bit about designing platforms for the social good. So this is something that I've worked on a lot in my research over the years. I wanted to start with a little bit of broad motivation. At least this is kind of how I started thinking about these topics. Here's a quote from a 2002 Roth paper: "The economic environment evolves, but it's also designed." And I think this is something that's very true in the tech sector. And for me, my motivation has come from these two broad shifts in economics. One has been this idea from Roth and others about the economist as an engineer, taking a more prescriptive lens, diving into the details of the institutional context to try to figure out how to create more efficient designs. And the second parallel movement has been this idea of choice architecture, where there's increasing recognition that we need to think about the choices that we're making and how a choice is being presented to customers and how that's going to affect outcomes. Now, zooming in a little bit to where my work has fit into this, I've been interested in applying these ideas within the tech sector. So Susan Athey and I have a 2019 JEP article thinking about the role that economics and economists have come to play, bringing ideas from the social sciences into companies. For me and for others, I know that this is often focused on understanding and redesigning platforms. Let me zoom in one more level to where I'm going to be thinking about in what I wanted to think about for the next few minutes, leveraging platforms for the social good. So this could mean a lot of different things, and I've worked on things in different areas around this theme, working with platforms to help understand how they could achieve socially good outcomes. So one example is Susan Athey, Kristen Graybarts, Nils Wernefelt, and I have a paper looking at digital public health interventions on Facebook and Instagram, and looking at ways to launch these at scale and evaluate their impact. Another one, we've worked with Yelp looking at digitizing disclosure initiatives. So this is with Daisy Day and I, Ginger, Dan Martin, and I have another paper related to this, where we're thinking about how do you design disclosure in the digital age, and what are some of the barriers to the disclosure mechanisms that might warrant more work. And the third area is what I want to talk about for the rest of this session, which is designing inclusive platforms. Let me give a little bit of backdrop specifically on that topic that'll motivate the way that I've been thinking about this. One design choice that platforms have thought about differently over the years is the level of anonymity in platform settings. So we can think about some of the early platforms like the eBays, the Amazons, the Pricelines of the world. And one thing that they did is help to facilitate arm's length transactions. You could be sitting in Boston and transact with somebody in Berkeley and not know much about the buyer or seller, and just kind of rely on reviews and these other mechanisms that came up in the last discussion. And that had important implications for efficiency. So kind of more products, lower prices, all of those implications, but also had implications for equity on the platform. And in fact, so some of the early research on this topic posited that this meant that the digital age was going to usher in settings that would have less discrimination, because you're removing some of the information that people would use to discriminate based on. But over time, we've seen pretty dramatic and often deliberate shifts toward less anonymity in transactions. So you could see things going back to at least 2010. Here's a quote from a Facebook marketing director saying online anonymity has to go away. Here's a 2013 line from Brian Chesky, the CEO of Airbnb, saying, when you remove anonymity, it brings out the best in people. And these weren't just words, actually kind of platforms started making decisions to infuse more information about buyers and sellers before you're making a transaction. And sort of the intended consequence of this was to facilitate trust. And the thing that I've been interested in is that there's also unintended consequences of this, which is that this can facilitate discrimination on a platform by reinfusing information about people you're transacting with. So I've been working on a series of projects thinking about when is this going to lead to discrimination, and are there times where providing information about people you're transacting with might actually mitigate bias or create more inclusivity. So in a paper with Ben Edelman and Dan Svirsky in AJ Applied 2017, we ran a large-scale experiment on Airbnb where we had drawn 6,400 properties that had listed availability 8 weeks out, and we ran a traditional audit study. You've probably seen lots of these in labor markets and elsewhere. So we took this basic idea and we varied only the name and had names that were statistically indicative of race. So names that are more common among African Americans and more common among white Americans, while keeping the rest of the message the same. And we found pretty pervasive discrimination on the platform. Guests with distinctively African American names based on birth records were about 16% less likely to be accepted relative to those with distinctively white names. We found that this was persistent, and the persistence actually is policy relevant because there's actually exceptions, at least in the US, for who would be subject to discrimination laws in housing. So it includes discrimination existed among shared and separate properties, and also hosts with multiple listings. If you look at the paper, we have lots of other heterogeneity in there as well. But let me just kind of zoom forward because I want to talk about the implications of this and also a new project that we've been working on. So in response to our paper, they gave a growing chorus of concerns about discrimination on the platform. Airbnb made a couple of announcements. They had a series of changes, but two I'll focus on here. One, they ended up removing profile pictures until after a transaction was made. So instead of seeing the person who's requesting to book and then deciding whether to accept or reject them, now you have to decide whether to accept or reject a booking request, and then you can see the picture. And the second is a pilot that they're still running that's based on Oregon guests, where they are actually now removing names until after the booking and only showing initials. And actually, this is a pretty common strategy if you think about like the removing of identifying information within economics. There's lots of settings where people have explored this broad idea. So you can think about kind of the Airbnbs and online platforms. We can think about the famous orchestra study, looking at people that are auditioning either behind a screen or not. That's a form of removing identifying information about gender and how that had implications for the gender composition of orchestras. Labor markets, so there's platforms that like Applied that are trying to do this, and they're all based on this simple idea, which is identifying information facilitates discrimination, and removing it could help to kind of then reduce discrimination on platform. So in the new paper, Abe and Asia, Oren Reshef and I have been looking at whether providing information about race can ever increase demand. And our motivation here is that there's a growing number of platforms thinking about, at least in a targeted way, saying, yes, there's discrimination, but there are also areas of the world where there's pent-up demand to provide support for marginalized groups. And where we look at one case study of a platform that designed a feature to help bring attention to Black-owned businesses. What we're interested in is, can these platform design changes leverage consumer demand to help a marginalized group? The empirical context we're going to be looking at is Yelp. In 2020, Yelp launched a feature that highlighted Black-owned businesses. It allowed Black-owned businesses to opt in to receive a label and to be more easily found in search. And they allowed consumers to search for Black-owned businesses near them. Let me just give a preview of the analysis, because I know we're on a tight time frame here and I want to stick to it. So what we do in the paper is we compare demand at businesses after relative to before the launch of the feature for Black-owned businesses relative to all other businesses looking within the restaurant industry. We're going to have a series of outcomes. We actually have outcomes on the platform, outcomes off the platform. On the platform, we look at clicks to the business, orders via the platform, and then we now have been able to merge in data from SafeGraph, so cell phone pings, to see if there's also additional people going to the restaurant afterwards. Then what we're able to do is look at some heterogeneity with an eye toward thinking about mechanisms. And the two flavors of things we do are looking across neighborhoods to try to get a sense of where the effect is larger or smaller, and also looking at who the marginal consumers are, who are the people being drawn in by the feature, to give us a sense of the racial composition of the new demand that's coming in as a result. Here's a quick preview of the results, and I'll give a little bit more context afterwards. But the new feature increased demand for Black-owned businesses. This was true both for on-platform metrics, but also true for the SafeGraph data, suggesting that this is an economically meaningful effect for businesses. Now, the effect was larger in areas that were predominantly white, higher income, and Democratic leaning. And we also find that the new customers for Black-owned businesses after the feature was introduced were more likely to be white relative to prior customers. And this is important for us because we were thinking about Is this reflecting homophily? So just somebody who wants to support someone within their own group, or is this something that you might think about as allyship, where there's a broader set of demand to help Black-owned businesses or support Black-owned businesses? Now, here's a quick snapshot of what the feature looks like. You can see there's 1, 2, 3, 4, 5 things listed up top. One of them is Black-owned. That is the feature. And 2 ways people find businesses would either be clicking on that or searching for Black-owned restaurants. And if you click on a restaurant, they also have a tag on there, a badge that allows people to see. So this isn't the only way people find restaurants on Yelp. So here's an example of a restaurant. Black-owned restaurants, Jamaica Plain is one of the common searches that people that got to Ula Cafe by, but they also got there by the existing channels on Yelp: breakfast sandwich, Jamaica Plain, coffee shop, Jamaica Plain. And businesses were, again, opting in with this. In our analysis, we're basically going to be looking at 2 things. The first, we're going to look at the timing of the launch to give us clean identification on businesses that are where the timing is pretty exogenous. And then we're going to look at staggered adoption over time. Here's just a quick snapshot of results, just so we can give people a sense. We see pretty dramatic and pretty fast increases. So we're pretty comfortable thinking that this is the effect of the feature rather than other demand shifts that are happening at the time. Like, kind of pick your outcome of choice here. This is page views, website visits, calls to the restaurant, orders on the platform, and revenue coming through orders. And across the board, you see the effects here. Yeah. Now, let me kind of dive a little bit into this heterogeneity, because I do think this is important for understanding the mechanisms. One hypothesis is just that whatever you make salient is going to drive demand. But actually, our results seem to suggest that it depends on what the underlying demand function is and what people seem to care about in an area. And the way that we get at this is look at heterogeneity in political preferences. So just an institutional detail is that within the United States, there's a pretty big political divide on views of race. So for example, this is just from a Pew survey. If you survey people who are Republican or lean Republican, there's only 16% of white adults who support the Black Lives Matter movement. Whereas if you look at Democratic leaning and Democratic white adults, there's 88% support. So there's good reason to think that there might be heterogeneity in the underlying demand for supporting a Black-owned business. And in fact, when we take that to the data, we merge in voter data on Democratic leaning and Republican leaning areas and see essentially the entire effect is being driven by majority Democratic areas, which suggests that this is an interaction of the design choice the platform is making, the launch of the feature, and also the underlying demand of customers. Again, we're able to look at who are the marginal customers. I'll just sort of dive right into it. So we do this in 2 ways. We look at the demographics of the area, and we find that the result is being driven predominantly by less Black areas, and areas that had a high % Black population didn't see a spike in demand. And consistent with that, we code up the race of reviewers based on their pictures using an algorithm called deepface. And we see that the effect is being driven by non-Black reviewers, and that there's a shift toward more non-Black reviewers among Black-owned businesses that get added. So let me just take the last minute and a half and sort of wrap up like where we are in this project and the way that we've been thinking about this. I don't take these results to mean that racial bias is not a problem even in this context. Racial bias is obviously prevalent in lots of settings. And in most settings, if you run an audit study and you're identifying race, there seems to be at least some extent of discrimination, and targeted anonymity can be helpful. But there's also important social movements that are kind of varying across geography and across preferences that are aimed at supporting historically marginalized groups. And at least in this setting, increasing the salience of race in a targeted way seems to have the potential to help marginalized groups. Let me just kind of recap the results a little bit and zoom out one more layer. So the support doesn't seem to be coming from other members of marginalized groups, perhaps because they already knew about these businesses, but it seems that it's non-Black restaurant goers that are learning about and then going to Black-owned restaurants, but that the effect seems to depend on the political preferences in the area and driven predominantly by majority Democrat areas. So zooming out even more, kind of thinking about designing of inclusive platforms, this says something about the need for more nuanced theories of race, what our preference is, how can a platform make design choices that will create inclusivity, and zooming out even one more level, just for in the spirit of this conference, I think this is an example of the potential for research on the digital economy. This provides testing ground for existing theories and ideas, but also raises new research questions and opportunities to pretty directly inform practice through research. So let me just stop here and thank you.
Thank you, Michael. I'm honored to have opportunity to discuss Professor Chen and Professor Luca's presentation. Let me share my slides. Could you see my slide?
Yes, perfect.
Okay, that's great. So I think both Long and Mike have mentioned the situation that platforms can find new opportunities to create value and generate win-win outcomes. This could be Alibaba's digital information structure that helps sellers and buyers. It could be the information structure Mike mentioned that help some people to find Black-owned businesses, and that could be beneficial to both sides. I think these are relatively easy cases. The more difficult cases are the situation where there might be winners and the losers. I want to give you 3 examples from my own research and my own observation of business practices. The first challenge is that a platform policy could benefit some users, but hurt others. Let me give you an example from Airbnb. So we know Airbnb guests are concerned about neighborhood safety. And if they see a review about a listing that mentions about neighborhood safety, especially in negative ways, they're going to respond negatively by either avoid booking in that listing or demand a lower price. However, we know reviews could be subjective, and listings in riskier neighborhoods cannot change neighborhood safety by themselves. Statistically, listings in low-income and minority neighborhoods are more likely to have negative safety reviews, and official crime statistics are higher in low-income and minority neighborhoods. So if you put all these together, the platforms sort of face a tricky situation. If they try to highlight safety reviews, that would help guests, but potentially hurt low-income and minority hosts. However, if they try to remove or downplay safety reviews, it could help low-income minority hosts, but may hurt guests and also hurt other hosts who happen to be located in safer neighborhood. So the question is, how shall the platform balance the two when there are both winners and losers? Or should we think platform have the responsibility to choose such a balance, to choose who is a winner, who is a loser? I don't see obvious solution to this. I'm just putting this forward to make everybody think this as a potential challenge in practice. The second challenge I see is, we know in many markets, the digital platforms have replaced part of traditional business. E-commerce may have replaced some of the traditional retail, ride sharing may have replaced some traditional taxi, and house sharing have replaced some hotel services. Then the question is, to what extent should those platforms be responsible for these displaced businesses? Of course, if the platforms win the competition by unfair competition, antitrust authorities should chime in and enforce. But what if the platform win by efficiency? Should they still be responsible for those displaced businesses? If the answer is no, what about the workers in those displaced businesses? Should the platforms try to provide some professional trainings or donate some help for rebuild of the community, or even pay higher tax so that the other departments of the society can do that function? So this is the second challenge I see. The third challenge, I think already mentioned by presenters in the last session, should the platform be responsible for bad players that abuse platforms? We have seen many forms of abuse. This could be unintentional from the platform's perspective. However, some platform services do facilitate those bad play. It could be long-distance financial fraud between strangers. It could be creation, distribution of misinformation. And we also see cases like cyberbully or sex trafficking and cyber addiction. So some of the bad plays already sort of entailed some regulatory approach. For example, in the US, as Professor Yo has mentioned, they Section 230 have carved out for sex trafficking, but still discussing on other issues. So this begs the question, should the platform be responsible for the bad play itself, or should they only be responsible for monitoring and policing the bad play? And to what extent should they be responsible on those policing function? Where is the boundary? So just coming back to Professor Chen's mentioning about the principles, the first principle Long has mentioned is the design of responsibility should be based on how a platform creates value. I think I totally agree. The key question is how we define and weight the value to different parties. As I mentioned before, there could be winners and losers. Different parties may have different value from the platform, and some may get negative value on that. How can we define overall value with appropriate weights? The second principle Long mentioned is from shared value, and that should provide a guidance for shared responsibility. I think the question I'm posing here is, should the responsibility be proportional to the value that eventually accrue to different stakeholders, or to the marginal value that a party enables to create to the whole society, even if that value does not necessarily accrue to the party, but it's enabled by the party, including externalities? I think Marshall already have some thoughts on this. And the third one is the allocation of responsibility should be shared in an efficient and fair way. I think this definitely is a laudable goal. The key question is, how are we going to define efficiency and fairness, especially what if they conflict with each other, at least in some people's mind? So I think these are open questions. I hope the discussion of the group, and maybe in the next session as well, will shed light on these questions. So I'm going to stop sharing my slide. Okay, does anybody have any question about this section, about the practice we have observed in digital platforms and digital platform designs? Okay, if not, let's move on to the next section. Many speakers have mentioned European regulatory framework, and clearly I think Europe has been in the leading of thinking potential regulations and guardrails for digital platforms. So let's welcome Professor Jacques Crémer from Toulouse School of Economics. Professor Crémer has done extensive work in organizational theory and the economics of digital platforms, and he was a special advisor to European Commissioner Baxter from 2016 to 2019. We also lead the policy report from European Commission on digital competition. So we really welcome Professor Crémer to share his thoughts.
Thank you very much. Can you see my screen?
Yes. Mm-hmm.
Well, thank you very much to Luohan Academy for inviting me to present. It's a great honor and a great pleasure to join this group of very distinguished scholars, some of which are very good friends, to discuss the issues of platform responsibility. It's also a bit scary, by the way, to have as a commentator Eric Maskin, but that's another issue. Now, what? Oh, sorry. I'm having a problem going from one slide to the next. Right. What I'd like to do is to focus on two ambiguities in the discussion, and that's why I added regulators in the title. The first ambiguity is that there are lots of the problem of a definition of responsibility. There are lots of definitions of responsibility, and they don't all mean the same thing. For instance, I'm responsible for the happiness of my hamster. Doesn't have the same responsibility, doesn't have the same meaning as in my responsibilities include cleaning the cage of my hamster. The second problem is that when we change the responsibilities of a platform, we also change the responsibilities of the regulators. And I don't think that we can discuss what are the responsibilities we should give to the platforms without discussing what are the responsibilities we give to the regulators. So I will discuss this in the context of a shift from a competition policy to ex-ante regulation, which is taking place all over the world. So, I mean, let me explain. The underlying premise of much of our discussions is that we want platforms to take more responsibility for the consequences of their actions. For instance, and as we've discussed extensively, social networks should be more responsible for policing dangerous speech on their platforms. In that sentence, the responsibility has two meanings. The first one is that the social media has a duty to ensure that dangerous misinformation about drugs is not present on their platform, and they must deal with it. The second thing is that the second meaning is that social media will be heavily fined and will be punished if they have dangerous information on their platforms. And those two meanings are not quite similar. And in some sense, what Marshall was doing earlier was try to link those two definitions of responsibility, but we really need to be clear that they are different. The second problem is that the shift from a competition policy to regulation is going to increase, means that the platforms are in some sense less responsible and the regulators are going to be more responsible. In particular, when you do competition policy, you announce some objectives and you tell the platforms try to get it, keep the markets pro-competitive, working in the service of consumers. On the other hand, when you go to regulation, the regulators tell the firms how do they need to reach this objective. So to a first approximation, the responsibility for choosing the means to attain the objective is transferred from the platform to the regulators. If I'm right, we need to face the consequences of doing this. In part, that requires us to think about the incentives of the regulators. Otherwise, the system which we design will not be sustainable. Sorry, my screen sharing is not great. So let me make this a little bit more personal. A few years ago, I was honored to be named special advisor to Commissioner Vestager, the European Competition Commissioner, with two of colleagues, Heike Schweitzer and Yves Alexandre de Montjoie. We were asked to think about the future of competition policy for the digital economy. We produced a report. The cover wasn't very distinguished in its design, but you see it. I think the report was quite good. And we surveyed the challenges that the digital economy raised for competition policy, and we suggested a few reforms. For instance, we suggested that if a platform had a policy which impeded multi-homing, it would be a priori illegal, and the platform would have a burden of proof of proving that this practice was pro-competitive, good for the consumers. Now, I enjoyed writing the report. Some people said nice things about it. It gets me invited to panels such as this one. But as far as I know, none of the proposal was implemented by the EU. Instead, if you allow me a little bit of some exaggeration, the EU decided to switch from competition policy to regulation, at least as far as the digital economy is concerned. It's a caricature, okay? And this is a genesis of the Digital Market Act, which passed in 2022 and which is beginning to have its effects now. Now, I console myself by saying that maybe our report was so good that it convinced the Commission that it was impossible to reform competition policy and that we are responsible for the DMA. Tommaso Valletti is speaking just after me, and is forbidden to say that I'm wrong on this point. So to give you an example of consequences, the European Commission had begun proceedings against Amazon for a certain number of its practices. One of the cases were raised on the fact that Amazon as a seller was using the data it acquired about its competitors when it was acting as a marketplace in order to help design its product, estimate demand, and so on. The EU had begun a competition policy case against it. That practice is forbidden by the DMA, and which means that Amazon has settled the competition policy case, but clearly we've gone there from competition to regulation. To go a little bit further in our discussion, it may be worthwhile to have a caricatural model of competition policy. Okay? Basically, on competition policy, you've got some things you are always allowed to do. For instance, you can always develop a new technology as long as you respect the intellectual rights of others. There are some things which you're absolutely never allowed to do. For instance, you are never allowed to discuss prices with your competitors. And there are some things which you are allowed to do unless the competition authorities can prove that they're bad for the consumers. And for this last point, let me take an example, which is not properly speaking about platforms, but I think it's a very clear-cut example, and it affects some platform. The FTC has just proposed a rule that would make non-compete clauses in employment contracts illegal. Now, those are clauses which forbids an employee to get a job in a competitor after they've resigned from their employer. I think the very vast majority of economists would agree that there are circumstances where non-compete clauses are perfectly appropriate. Okay, so how would we defend the FTC proposal? Well, I think we would defend the FTC proposal as saying it's too complicated to write a rule which accepts appropriate and to enforce rules which accept appropriate non-compete clauses, and hence we're going to do something which is cheaper, which is just ban them all the way. Of course, there are errors here. The basic idea is that it's being too lenient is more costly than being too strict. And this example shows us that regulation works on a very different way. Basically, regulation says you can do this, you cannot do that. Now, of course, regulation has always existed in some dimensions. Okay? What the current movement is doing is transferring some practices from the competition policy angle to the regulation model. And and of course, full treatment will be much more complicated. The point I want to stress is that the regulation shifts responsibilities from the firms to the regulators. And in particular, if a non-compete ban is implemented, the FTC will become responsible for its consequences. And in particular, if the rule is badly written, it will be the FTC's responsibility, as opposed to what you could do, which is treat it under competition law or another type of law where you will give more responsibilities to the firm. So going back to the regulation of the big platforms, I will submit that there has not been enough discussions of the consequences of this shift in responsibilities. Sorry, let me. I apologize for my bad technology. Let me go through three consequences. But before beginning, I want to stress that I'm generally in favor of that shift from competition policy to regulation. And I really support the regulators who are trying to do this in an intelligent way. But I think that we do them a disservice if we don't help them implement this shift in regulation in a way which is appropriate and intelligent and balanced. The first point I think is very important is that the regulator must take responsibility for the failures of a regulation, and the systems must induce the regulator to do this, and they're bound to be some, and they should be able to correct them. And there's the GDPR, the European Data Protection Act, provides a cautionary tool in that regard. Many observers, and not only the nasty advocates of platforms or the free market fanatics, have criticized some of the aspects of the GDPR, but the European regulators have been more than reluctant to review it or even to discuss those criticisms. In the case of the Digital Market Act, there are only 2 articles, 19 and 53, which deal with evaluation and evolution of a regulation, and I find them rather weak. For instance, Article 53 calls for a regular evaluation of a DMA, but it's supposed to be done by the Commission itself. The second point is that the regulator has a responsibility to make regulations that are clear and unambiguous. And that's easy to say. It's sometimes very difficult in the political process to do this. But if we take Article 6.4 of the DMA, which you have on the screen, and it takes aim at the app stores of Apple and Android, the gatekeeper shall allow and technically enable the installation and effective use of third-party software application. So this means side loading, or software application stores, or competing application store. And there's a real problem to know whether the or means that the third parties are able to do, whether the Apple is going to be forced to allow both safe loading and another app store, or one or the other. And actually the German text says and at this point, and all the legal texts are the same. So there's a real problem of doing regulations which are clear. And again, when they go through the political process, it's very hard to do it, because one easy thing to do is to hide the political disagreements and in unclear regulation. Finally, the responsibility should be clearly allocated. And if we look at the Article 8.1 of the DMA, says first the gatekeeper shall ensure compliance with the obligations of the regulation. And it also, the second sentence, also notice, says the gatekeeper shall do that in a way where it makes sure that it's effective in achieving the objectives of its regulation. The second sentence is very problematic. Okay, first, the objectives of a DMA are fairness and contestability of markets, and those are defined only in a very cursory way in the regulation, so it's not entirely clear what they mean. And secondly, what happens if a regulation is badly drawn and doesn't, goes against contestability? How can you make the firms responsible for doing something with the regulation is preventing them to do? So there's a real problem of making sure that the responsibility are clearly allocated. Okay. Again, I want to stress that those are criticism of specific points, more for illustrative purposes. Overall, I think the DMA is a pretty good first step, and I support it. So as a conclusion, I think that the regulatory shift that we see all over the world transfers responsibility from the gatekeepers to the regulators. And we shouldn't say just that it increases that it changes the responsibilities of the gatekeepers. We should also look at the other side of the medal. We've done very, very little work in recent years on the economics of a regulatory system by itself, and particularly economists should do much more in order to help design the regulations and balance those responsibilities. Okay. Again, I've presented some very preliminary ideas. Thank you very much for giving me this opportunity.
Jacques, thank you so much for highlighting regulator responsibility and the boundary of that with platform responsibility. We'll move on to the next speaker, Professor Tommaso Valletti from the Business School of Imperial College London. Tommaso was the Chief competition economist at the European Commission between 2016 and 2019, and he's currently the director of the CEPR Research and Policy Network on Competition Policy. Tommaso, take it away.
Thank you very much. Can you see my presentation?
Not yet.
Okay, because I see I'm frozen, unfortunately. So these things happen. So, okay. For some reason.
I can see it.
Yeah, so I hope this can work. For some reason, I still see my screen a bit frozen, but let's go on. So it's a great pleasure to be with you this afternoon. I'm going to talk about the competition aspects very quickly, about competition among big tech. So my perspective is not about platforms in general, but about big technological platforms in particular. And because there is many cases at stake recently, let me make a disclaimer that I don't do any consultant work either for or against these big tech platforms, and nor I'm aware that my institution receives money from them. This is also an opportunity to take you through my personal journey as an economist that had a stint as an enforcer where I had to reassess some of my priors a little bit, which I had about platforms, which I had formed over time. And then I saw a couple of differences between, theory and practice. There was some disconnection. So when I think about big tech, and again, well, there you go. I see two different periods somehow. So when I talk about big tech, I'm going to talk about commercial internet. I'm going to talk the last 25 years of the commercial internet, maybe 30 years. And in the last 3 decades, you have somehow a first period, the first half of it, which is extremely innovative. Maybe there is a coincidence, but since I'm going to talk about competition and competition policy, also think that this initial period of incredible dynamism, disruptive innovation came along when the United States ran the last antitrust case in this area. So that was a Microsoft case in the mid to late 90s. And then the United States, until recently, effectively abdicated from intervening in the big tech sector. And so this is where, all the entrepreneurs were very familiar with Jeff Bezos and Brin and Page, and later on Zuckerberg came along. So here you got young people in Silicon Valley in the mid-90s. But then things changed. And this is where we have been a bit slow in catching up with what happened. So, and as a turning point, think about 2010, 2011, more or less. So it's been already more than 10 years. This is just, some anecdotal data points, but interesting to think about. And also how, as I said, I updated some of my priors. So this is just a simple master thesis from a student here at Imperial, Dutch. So you will see a very strange word there, which is autoverzekering, which means car insurance. And what this student was saying, just simple snapshots of what you see on the screens when you do a search. Okay, you did a search for car insurance, and 10, 15 years ago, you will see a lot of organic links and some paid stuff only at the top. By the way, sometimes it's not even clear those are paid links because these red boxes were superimposed by the student himself. So some people don't recognize it. But what this screenshot is basically saying is that over time, more and more of our attention was captured by paid ads, okay? Because that's the monetization business model of the search engine of Google. In principle, as an economist, I would have said, well, you can scroll down and you can see lots of other pages with lots of other organic links. But this is where there is one of the discrepancies I've encountered by running cases with the European Commission between theory and practice. People don't scroll down. People don't, okay? So when I was running the Google search, the Google shopping case, apologies, basically 99% of the people click either on the first or the second result they see. Okay? So this idea that people are rational, some of us are, but another lesson I learned is that when I speak to academics or very smart people, we are not representative of the overall market at all. So we don't need to think about ourselves, but we have to think about the average person. So this is, the search result is not necessarily what you're looking for, but the search result will be dictated by how much somebody is paying to have access to your attention, which is a scarce resource. That's another anecdotal data point. Yeah, this idea that the internet is a ladder to this infinite knowledge which is available out there, this amazing experience where everything is interconnected with everything else, which is true in theory, and that was the original promise of the internet. Well, this is again another data about Google once again, which tells that 2/3 of the searchers are so-called zero-click searches. That is, you start from Google and you end up there. So it's not a stepping stone into something else. Okay, so maybe you already get what you wanted. I don't know, but again, I had to revise this idea that you start a journey that that can go anywhere else instead. And again, relate to the business models of many of these companies. These companies try to create a moat in their own ecosystem. They want you to stay in their ecosystem as long as possible to make purchases, to send you ads, etc. And it's very difficult to get out of it. Again, Google, to talk about another idea that we had in mind as economists, but there is always competition for the market. Forget about competition in the market. Reversal of fortunes. This is data about the global dominance of Google's in search engines. As you can see, more or less 90 to 95% of the searches worldwide, forget about China, that's a different market, are on one search engine only. Okay, so 95% in Europe, for instance, it's 95% and even higher on mobile phones, because as you know, not only Android is owned by Google, but Google is also paying Apple in order to be the default search engine on their phones as well. So also on iOS, it's very difficult to promote the new search engines. I don't want to pick up necessarily only on Google. So this is Facebook. Now they call themselves Meta. So you may remember a couple of years ago, to the date, where the attempted coup in Capitol Hill. Unfortunately, a few days ago, we had a similar thing in Brazil. And on the day, January 6th, when there was an attempted coup in Capitol Hill in the United States, Facebook, that was still the name at the time, announced changes of the terms of service to WhatsApp. And in particular, there was a perception, which was correct, that the level of privacy would be reduced in the United States and the rest of the world, with the exception of Europe. And there was even perhaps some misinformation. People understood there was the end of encrypted messages. But people started saying, we have to do something, okay? This thing didn't go unnoticed. We have to do something in order to change platforms. So let's try to go on Signal, perhaps, okay? Let's download Signal because we need to introduce an alternative platform. And many of us perhaps did that. Okay, but then there's a difference between downloading an app and being able to use that app. Okay, this is the actual usage in that year, 2021. And basically, so maybe you do have a Signal on your phone and you may communicate with a couple of friends. Journalists do that, but that's it. But try to convince your mother, your friends, your chat groups, etc. It's impossible. Okay, it's impossible because of network effects. So what this slide is saying is that if you add up WhatsApp and Facebook Messenger, which is owned by the same company, if you remove Weixin and QQ, because this is China again, so it's that completely different market, basically nobody managed to get away from the monopoly that WhatsApp has on messaging services. And interestingly, Signal, for instance, is nowhere to be seen in actual consumption. So we have to distinguish between just downloading once an app and actually using it on a regular basis. So we had many questions by running cases. This is interesting perhaps for academics, since I had this experience as an enforcer. There is actually a lot of evidence which is lingering around, not from academic papers for some reasons I will tell you in a moment, but from cases. The downside of cases is that they're very long and boring to read. There's a lot of information there, but they're not written in a way which is very user-friendly. It's not just about the EU, and recently the United States moved in that direction too, but it's also South Korea, it's also Australia, it's also the United Kingdom, it's also, there is Japan. So there are many cases. Unfortunately, they are not digested well for an academic community. So some questions there became clear that the growth of this firm, which has been incredible, was because of merit. They do supply very good products, but there is something else. if Google is so good, why do they need to impose contractual restrictions on mobile phone manufacturers to have Android? Why do they need also to pre-install all the Google suite of products and so forth? If Google is so good, why do they need to pay $10 to $15 billion a year to Apple to be pre-installed also on the Apple phone? So this is where dominant companies, and this is a theme of today's conference, have special responsibilities. So no one ever said that, pre-installing is bad per se, or paying some money to be pre-installed is a bad thing. But when you're a dominant company, you have to think twice about those kind of behaviors, those contractual restrictions. So these are the many cases that we have run. It took endless time. So Google Shopping took 7 years, for instance, which is an infinity in a dynamic world of platforms. This growth came also through mergers. So in the past 20 years, there have been in excess now of 1,000 acquisitions by the GAFAM, okay? Nobody's saying that they were all bad, but the point, and again, as economists, try to confront yourselves, not just with a theoretical argument, but the actual numbers. None of them. Now I have revised the figure because one acquisition has been challenged by the UK authority, that was Giphy when it was purchased by Facebook. But 1,000 to 0 or 1,001 to 1, these are numbers that don't strike as good numbers. So everything, and more importantly, about 97 to 98% of these acquisitions, they were not even vetted by anyone. So for various reasons. So we tried in Europe at least to challenge some of this behavior especially on the behavioral side, on abuse of dominance side through cases. But it took, as I said, a long time, which is not compatible with the dynamics of the industry. So now we are still discussing about remedies in those cases that basically the competitors were dead 10 years ago, and you cannot go back in time, and competition has been lost almost forever. And this is also something which I encountered personally. And it's not surprising for an economist because of the asymmetric stakes. There's lots of money on one side, and then you have regulators that, yes, they should be having responsibilities, but they're also struggling with lack of resources. And so in the end, you've got the best advocates, the best economists, the best consultants always working on one side only. And academia is often not present in these cases. Still, we can do something. So what can policymakers do, and what can we do as academics? So policymakers, and Jacques already mentioned this, are basically shifting from the insuccess of exposed application of competition policy for several reasons to application of ex-ante regulation. And this is not surprising if you think these are industries where there are behavioral issues on the demand side, there is huge fixed costs, so entry is difficult, there are network externalities. These are industries from an economic point of view where competition is not expected to work fine. Okay, so it's a situation you would expect at some stage to some ex-ante regulator to come in force, which is what we're trying to do in Europe right now, and which is what China actually did before anyone else. So China has already enacted something very similar to what's in the DMA now. I call these traditional tools because although comparisons are always difficult to make, we have managed to introduce, say, some competition in telecoms, which has network effects, huge investments. It has a different political dimension because telecoms still are within national boundaries. Instead, these platforms are supranational, which is a very important topic to think about. But in telecoms, for instance, I am based in the UK. There are 4 mobile operators. The situation is okay. If I dislike Vodafone, say, which is one of the incumbents here, and I want to go on another operator, I keep my number. I can talk to anyone else on any platform. I keep also my contacts. I mean, imagine instead the problem I started with when I mentioned about Signal. You cannot keep, your contacts. You cannot talk to them. You cannot be interconnected. So some of the principles, especially the contestability principle, is not a regulation on prices, but it's a regulation trying to give competition a chance. Okay, and I think as a principle is something where I hope there is agreement. Something also that I've proposed many times, and it's more of a legal issue, but it's very important in practice. Currently, the discussion, especially in antitrust, is is focused in the wrong direction. What do I mean by that? I said earlier, there is really a resource issue, okay? So regulators don't have a lot of resources they can play around with. They cannot fight too many battles at the same time. However, most of the discussion is at the initial stage, that from the legal point of view, you have to define what's the relevant market. There is an obsession in antitrust circles with the relevant market, which are very elusive in digital platforms, yet resources, real resources, months and months and people, dozens of people are working. What is the relevant market? Is Google dominant there? And it's the wrong type of discussion, I think. I think I would be much more draconian and say, go back, and this is where my field, industrial organization, hasn't been very helpful. Go back a little bit in time, reintroduce some imperfect structural presumptions. When you are Google, when you have 80% market share at least, when you have, take some imperfect metric. Every metric will be imperfect, in my opinion, but it's better than what we couldn't do in the past 20 years. And when you have this kind of size and importance, structural importance in the economy, I will presume that you cannot, for instance, purchase another company. You don't need to purchase another company, yet again, gobble up a potential rival, despite all the uncertainties around it, because you have the resources to do it yourself. You can do it. Why on earth do you need to buy yet another one when you are the most almighty company? This is the structural presumption that I would reintroduce only for a limited set of players. But then there is the rebuttable bit. And the rebuttable bit is I will say this is bad. And I can also do this be special with certain behaviors, unless you prove me, you Google or Facebook or Amazon, whatever, you prove me that you really need that action or that merger, etc., to do something that otherwise you couldn't do, and it's going to be beneficial to consumers. Okay? This is the rebuttable part. So I hope you can see that all the discussion will avoid this endless, time, effort and money burning exercise that the regulators are doing, and instead we would concentrate on the real meat. But it would be the companies that would have to bring some evidence to the regulator in order to discuss about the evidence and why a certain merger or a certain behavior is to be done. What can academics do? I still have another slide and then I'm done. The problem of academics that we've encountered is that basically we got stuck. We got stuck to where we were 20 years ago when we developed the theory of two-sided markets. If you think about the policy debate of some people now, is still where we were 20 years ago. So these platforms, network externalities, they are great. They create markets. This is fantastic. It's efficient. However, this comes potentially with the cost of monopolization. Okay. So, and this debate was there 20 years ago. The debate is still there now. And so it's an empirical matter. So you would have hoped that progress could have been made on the empirical side. But this is the downside. The downside is when it comes to these big companies, they never gave data, especially on the competition side, to independent academics for an evaluation. So it's been very, very difficult to obtain anything. So just look at the top 5 journals in the profession in the past 20, 25 years. Despite the relevance and the interest in the topic, try to count how many articles have been published with primary data coming from Google, Facebook, or Amazon, or Microsoft, whatever. Okay, Microsoft is a bit of an exception because they have a cultural difference. They have the Microsoft labs where they do research. So the big tech problem is that they don't give data. De facto, they don't. Okay, and then there is the Uber problem. Sometimes there are some platforms which are willing to give data. Uber is there. It's a case in point. There are many people with Uber. Uber is not one of the dominant companies, by the way. However, Uber gives data to some researcher only if somehow the research question is preordained. So you already know where the question is going to get to. So there's a famous paper, for instance, and this I've been discussing, for instance, with Luigi Zingale, as you might have heard in other settings, where Uber was accused of discriminating between female and male drivers. And so they gave data to very good economists at the Chicago University who actually did a data analysis, and they said, no, it's actually that the male drivers drive faster. So they don't earn more, but they just have more rights. They can have more rights in a given point of time. That's why they earn more. There is no discrimination. As an economist, you would immediately say, okay, but if I drive faster, is it going to create a higher risk of accident? Is there a trade-off? No, that's an interesting economic question. Did that induce some moral hazard, some behavior that was not good for welfare? But when the same academics asked Uber, can we also analyze that aspect? Uber said, no, you cannot look at that. You can only look at one aspect of the story, and we're not going to tell you anything else about the rest. And this is not acceptable, because this partial evidence, of course, will always be put and packaged in a way which is beneficial to the companies, and you want to know more. There is hope, okay? In Europe, for instance, there's an academic community as part of the DSA, not the DMA, the Digital Services Act. There is a provision, which is, I think, Article 18. I'm very bad with these things, which oblige actually the companies which are subject to regulation to release data to academics for research purposes. So you have to get gear for that and make sure that the interfaces are done well, make sure that the anonymization of data is done well, because it's an opportunity, but it can also be a wasted opportunity if data are collected in the wrong way and if they cannot be transferred in a good way. There's also a true call for interdisciplinarity, because here we're talking about privacy, we're talking about stuff which is not the typical realm of economists. My view, again, very personal, perhaps parochial, but I have observed a tendency, maybe it's the typical way we are trained, of economists of looking at the flaws of regulations, okay? GDPR is a case in point. Let's look at the cost to firms that they cannot advertise. But regulators are not silly people. Regulators introduce sometimes regulation for a reason. No? They want to make sure that our privacy is protected. And for a reason or whatever, I don't see really a lot of interest in trying to understand the benefits of regulation as well. So for instance, I haven't seen many papers on looking whether people feel more protected by GDPR, just looking at the commercial aspect of GDPR, which is again a partial view. Fine to look at one aspect only, but let's be broader. When I speak to privacy experts, especially on the legal side, though, I clash with another problem, because they say, you economists want to quantify everything. That's your problem. I don't know if it is a problem. I think it's a good thing to try to quantify something. It's informative. However, they tell me, which is something I can relate to emotionally, when they tell me privacy is a fundamental right. But then I need them to explain me, what does that mean? What does it mean? How can I introduce that legal important concept of rights into an economic framework? And this is something which has not been done. So this discussion has to be two-way and useful. We need to change vantage point. I will conclude, though, because this is a panel of very distinguished people and researchers which are still very active in this area, with a call to try now and then, and this is also one of those occasions, to do something different and to try to change really vantage point by looking beyond where we are now. So, because in the end, and I find it intellectually sometimes not too satisfactory, we're always talking about the same stuff. We're talking about, apps, advertisers, platform. It's always that. That's where we are. And instead, and I don't know if this makes any sense, but let me try to say it anyway. Let's try to ignore for once Google and Amazon and Facebook or Meta. Let's try to ignore them for one. Let's try to talk among ourselves, but also with people from other disciplines, about where we would like to be 10 years from now when it comes to our social relations, the way we shop online, the way we are informed online. Let's try to think about our digital future. There will be a variety of opinions, okay, of course, but only by putting ourselves, and of course, in this digital future, there will be Google, there will be Amazon, there will be all of those, but we can be more ambitious, no? Because we will see that there may be something that we are not thinking about yet, and we can try to figure out how we want our digital future to be shaped, because only in that way then we can find solution also for our digital present. Thank you very much.
Thank you, Tommaso, for sharing your experience and perspective. Our discussant is Professor Eric Maskin from Harvard University. Professor Maskin has won the 2007 Nobel Prize. He's one of the founding fathers in mechanism design theory. So Eric, please take away.
Thanks very much, Ginger, and many thanks to Jacques and Tommaso for some very interesting and thoughtful remarks on how to get platforms to behave responsibly, that is, in a way that benefits society. Time is short, and so I think I'm going to be very brief in my discussion. I just like to summarize some of the points that Jacques and Tommaso made from my point of view. I would say that based on their discussion, there are three ways in which government can try to get platforms to behave in a pro-social way. The first is to pass a law that platforms must act in a way that does not restrain trade. They mustn't act anti-competitively. This is what Jacques was calling competition policy. The second is to introduce an outright ban on certain practices. For example, you can make it illegal for a platform that hosts widget sellers to sell its own widgets on that platform. And the third possibility, which Tommaso had on his slides, but wasn't really discussed by either speaker, is to break the platform up and to create competition instantly, since the various pieces will then be rivals of one another. Now, of course, historically, all three strategies have been used, not so much in the digital world, but looking more broadly, at one time or another, going back to the 20th century. So far, when it comes to platforms, digital platforms, governments in the United States and Europe, until quite recently, have followed the first strategy. You'll recall that 25 years ago, the US government sued Microsoft, saying that bundling its software was putting Netscape at an unfair disadvantage. And in the end, Microsoft had to stop doing this. This is the strategy that I think it's fair to say economists tend to gravitate toward naturally, because it's the most nuanced. That is, there's a particular practice by a particular platform that's examined, and the costs and benefits of that practice are weighed up in court. And if the costs are deemed to exceed the benefits, the company is told that it can't continue the practice. Simply banning certain practices, a platform selling their own products in competition with other sellers, is cruder. And no doubt it doesn't get things right all the time. There are cases where the benefits of the ban will exceed the cost, but there are probably plenty of cases where it goes the other way. But as both Jacques and Tommaso noted, despite its crudeness, bans are increasingly becoming the strategy of choice, because first, they're simpler. Second, they are relatively unambiguous. And third, they're quicker. There doesn't have to be a protracted legal battle adding up the costs and benefits. And as Tommaso was saying, in too many cases, the issue became moot because the industry moved on anyway. But I think there's another reason why we're seeing a greater emphasis on regulation. And that is a widespread feeling that the first strategy, the more subtle strategy, has failed. One might have thought nearly 30 years ago when Amazon was founded that by now it would have a lot of competition in the e-tail business. But in fact, it has surprisingly little competition. Now, exactly why this is the case is a fascinating and important question. I'm particularly intrigued by the theory that through learning by doing, Amazon has developed software that is far better than anyone else's. And because that software is proprietary, the gap between Amazon and its competitors remains large and it is perhaps growing. But whatever the reason for Amazon's continued dominance, and same is true for Google's continued dominance and Facebook's continued dominance. This leads me to the third strategy, which Tommaso called breakup with an exclamation point. I suspect that regulation, bans, are also not by themselves going to prevent the giant platforms like Amazon, Google, and Facebook from remaining pretty dominant. And so there is going to be increasing public pressure to divide these giants up into smaller pieces. And let me now make a remark which for an economist might be viewed as heresy. I'm going to suggest that perhaps this would be a good idea. And I'll propose two reasons. First, the historical experience with breaking up companies, at least in the United States, has been reasonably positive. The two big examples are the breakup of Standard Oil in the early 20th century and the breakup of AT&T in the late 20th century. And of course, in both cases, one can argue that it was a mixed outcome, but you can make the case, and many have, that on balance, both benefited consumers. So the historical experience suggests that breaking up dominant firms can be an effective solution, but perhaps an even more important point is that quite apart from their economic power, the giant platforms have enormous political power. And in a democratic country like the United States, having that much power invested in entities that are not directly accountable to the public can be worrisome. So although I celebrate, as an economist, the nuance and subtlety of strategy one, and I might even endorse as an economist a shift towards strategy two, I think it may also be very much worth considering the breakup strategy three as well. Thank you.
Thank you, Eric. We have some chat window links to previous studies by some of our speakers and related references. Let's open up the floor discussion. Anybody have any point want to make about either the presentations in the event or just your opinion on related issues? Okay, Tommaso, well, I'm sorry.
I'll go for one comment, actually, because I do think that the issue of breakup is a fascinating one. And one worries that the divisions might reduce, in some sense, the network effects or the opportunities creating network effects. Another possibility, however, might not be breaking up the structure, but might be breaking up the governance in such a way that we create governance on top. The issue is that the underlying resources, data, are non-rivalrous, so that multiple parties could share them. So rather than treating them like rival assets, where the benefit of competition is to split them up and then reduce prices by having multiple parties control them, it might be possible to create governance structures within which multiple parties gained access to the data, and then from which multiple parties were able to create network effects and therefore create value. So I actually think in many ways the question should be one of how do we create value then divide it, as opposed to how to create competition. And I would in some sense reverse the question before settling on breakup. Again, far be it for me to contradict Nobel Prize winner in here. I think we have some really interesting challenges, but I do think that if we focus on the question of value creation first, we may be able to use governance structures and competition among governance structures to achieve the same ends with greater value.
Thank you, Marshall. Anybody want to respond? Let's see. Marianne Bolton has a question for speakers in section 1. Marianne, do you want to speak up?
Yes, thank you. Miriam Buiten, University of St. Gallen. Yes, yeah. So my question would be, so from the European perspective, where the Digital Services Act has now been introduced that tries to basically regulate how platforms remove content rather than making them liable for the outcomes of that. We saw today, and especially in the first session, that a lot of the issues have to do with not illegal content, but with this whole fake news and disinformation. And so here the harm is a lot more diffuse, and it is also a bit harder to regulate because even in the European setting where notice and takedown has been around for many years, you cannot so easily say, well, platforms should just remove it, right? And so I wonder what you think, what the speakers think of the role of liability or regulation for this aspect of this legal content where the harm is more on a meta level and more diffuse than for illegal pieces of content. Thank you.
Did you have a particular speaker in mind? Chris is also on the same panel, or maybe that was directed at me.
Both of you.
So one of the purposes of the mechanism that I was proposing on being willing to warrant content, and if we borrow some of the ideas of Ronald Coase, the warrant has to be in the amount of an expected externality. So it would be, in the case of pollution, it would be what would be the expected damage. On average, you're quite correct. There's a phrase of there's lawful but awful content, and there are many cases when there might be damage for things that are in fact lawful. The thing about the warrant is that anyone could challenge it. And so by design, the hope is that anyone who is experiencing the harm could challenge the validity of the content and thereby claim the warrant, if you will, which makes what it does is it gets the speaker to internalize the harm by in effect bearing the cost. The point of the Coasean market is that anybody could make that claim, that even for lawful but awful content that were warranted, they could then receive recompense on it. So anyone could claim it. There's another interesting question that always comes up is, well, how would you set it? How would you know what the harms would be? And this is another case when I actually think we can create an efficient market in search. So imagine that a fossil fuels company keeps warranting content that people don't cause pollution or don't cause global warming. In that case, what we've learned is that the individual profits are so much greater than the cost. What we need to do is to increase the liability, exactly like someone that keeps wrecking a car, their insurance should go up. So if the same claim keeps proving false and keeps getting warranted, then you would raise the price, if you will, to find a mechanism which actually then tries to locate the level of harm. So I'm hoping that by design, this would be a way of transferring the harm from the party that's causing it, the party that's experiencing it to the party, back to the party that's causing it. And then B, finding an efficient search mechanism, which would allow you to set it in the proper levels. I'm hoping these would be solutions to that problem, even for the lawful but awful content.
So really quickly, I understand, Marshall, your desire to try to get the incentives aligned. To me, it's still all derivative of defining the scope of liability and the entitlements, because in the end, you're trying to create that market, and that's going to be the devil. In answer to the specific questions, I think that the kinds of we've tried, there's been some experiments with this idea. What we're seeing increasingly, Miriam, is what you're talking about is what we often call soft facts, which is not, a literal fact, but in fact an interpretation of the fact about, say the efficacy of some COVID treatments or whatever, which evolve and, that require a good deal of interpretation. Those have been really, really hard to establish. And even things between distinctions between political and non-political speech, in a world where we find that a great deal of politics is socially constructed, it's really hard. I mean, because on some level, movies are deeply political, photographs are deeply political, depending on the subject matter, and satire. I mean, it's become very, very hard to do. And so definitionally, it's going to be hard, but more importantly, the thing that I always worry about is unintended consequences, which is we don't understand these markets that well, and squeezing one end of the balloon, unfortunately, in the past has caused some very strange expansions in areas we didn't anticipate. So whether we're doing it through a warrant system or direct liability, it's not an area we understand very well, and that runs risks.
Thank you, Chris. Seems like Randy Xu has a follow-up question for Marshall. Randy, do you want to say it? Okay.
May I say something?
Mm-hmm. Yep.
Yeah, so I want to add the discussion a little bit. Firstly, I want to point out, after Eric Maskin has said, I think a lot of this discussion we're talking about is really centered on the US experience. I'd like to point out the fact that if you think about China is another digital economy, it's big digital economy. And in most of the areas, I do not see any player. Ginger can correct me, I don't think you can. In most of areas, I do not see anybody is dominating going up. I think there's a lot of competition in most of the areas I can think of. So it's not as, anyway, it's fascinating to think about the logic, but US is not only story. Of course, Europe is another story, but it's affected by US. But I think it's not just about US. That's my first point. Let people think about. Second, and I'm coming back to Ginger's recommendations, and I think you ask a lot of good questions. And that's another, give me a chance to talk about another side I think is interesting to talk about. It's that because a platform is really, its ecosystem involves a lot of stakeholders. So nowadays, actually, there's a rise of talking about the ESG responsibilities. It's environmental, social, and governance issues. And now it's more and more requested on the, when you go public. But because a platform is really has to integrate the demand from the stakeholders, it's actually natural to think about, well, you combine what are the values, what are the social, the standards you should hold up to. And that's probably can partly answer Ginger's question. So we're not sure, obviously there's no absolute, everybody's winner, but there's a set of values, actually the society values more. For example, fairness, inclusion, a lot of stuff. And actually, I think the platforms, because of the leveraging power of engaging multiple stakeholders, they are also a very good the ground, to promote ESG, the social values, environmental issues, all the social values. And so that's another thing to look to, other side of the things to mitigate the the concerns for the platform or implement social responsibilities without have absolute standard about what is absolutely right, what is not right, because it's really about engaging all stakeholders requirements. So those are the couple of comments I want to talk about. And finally, I think the way we talk about this evening and talk about for this people or this morning, we can appreciate that there's not enough economics of the responsibilities talking about here. Looking at the standard, even for the regulations, it is very vastly different definitions across the states. That really means that there's no absolute right or wrong. And we really need to think about more the logic going on here to make the discussion subtler than what we think. Thank you.
Thank you, Long. Mike, Luca, you have a comment?
Yeah, so thanks everybody for a great discussion. Just wanted to build on to Long Chen's comment here, which I think is an important one on the role of firms in thinking about this. It seems like there's a lot of focus on the policy questions, which are obviously super important. Now, I also wonder though, if there are areas where companies are making mistakes in their bad behavior. Like, so if something is going wrong, it could be that there's ill intent, or it could be that there's something that's missing from their objective function. And just to get a little bit more concrete about what that might mean, if you think about the types of analytics that are common in large tech companies, like they're tracking kind of short run experiments that have very short run outcomes. So yeah, if you're running something on a 10-day A/B test, and that's the process you're making to decide whether to shroud fees or not shroud fees, whether to self-preference or not, then it seems like it may push companies toward having outcomes that are either too short run or too narrow. And I do wonder if there are opportunities within firms, even in the current regulatory frameworks, to try to get better at bringing in broader sets of variables and trying to have a better sense of longer run impacts of the changes they're making. What might that look like? So reducing discrimination is one thing, where it's like once you sort of bring that to the objective function, so Airbnb and others have now started to track that, but there's other examples too. So there are companies that shroud. A lot of the shrouding of prices come from short run experiments that show that it's pretty profitable. Some of the medium run experiments also show it's profitable, but even having seen that evidence, companies like Airbnb are now saying, well, we're going to override the data. And it just seems important to have a framework. And I think the field of economics has a lot that it could contribute to that framework to understand what are the potential mistakes, especially on ways that could kind of help move toward a better platform ecosystem.
Thank you, Mike. We're already past the officially scheduled time, but we'll keep the value open for the next 10 minutes if people want to continue discussion. I want to thank every presenter and commenter here for joining the discussion. We'll keep the value open if people are still interested in continuing the discussion.
Can I comment on what Michael just said? And I hate what I'm going to do, because this is going to be again one of those things, oh, life is more complicated than what he... I think the problem is even more fundamental than the problem of whether or not there's racism, discrimination, and so on. Take Facebook. Okay, the algorithm of Facebook decides whether or not you're going to keep in touch with your aunt twice removed, with your childhood friends, or with your university friends. Okay, so basically Facebook, in some sense, is deciding who you're going to keep contacts with, and does that for an algorithm which we really don't understand the outcome. So there's a problem. I agree with you that there is a problem of, social value of a network, of platforms, but I think it's more fundamental, and there's really something we don't understand very well. I mean, same thing happens with Twitter. Twitter has probably changed its algorithm recently. We see different things on Twitter, but we don't really understand why. We don't really have any way to measure whether it's better socially or not. We don't even, and I think I'm really frustrated by this problem, but I just wanted to bring it forward.
Thank you, Jacques. Anybody else want to chime in?
Bernd has his hand up.
Professor Ben Helmström raised his hand.
Oh, okay. I don't see it somehow.
Yeah. So I only have a real hand, not a virtual hand. So I have a question of Long usually, or I have heard it many times say, and I think it's right, that China has a lot more competition than the United States. So it seems to me that somebody should start thinking of why this is, and do you have views, Long, why, what is it that accounts for this big difference? I mean, I understand that these countries are very different, but is there anything that you sense is critical for the competition in China?
I know the facts. I know in China, in most of the area I'm familiar with, in obviously e-commerce, searching, payment, most of the areas, I think the market share of any company is going down. So it's a lot of fierce competition, new innovations, new models coming up. Why isn't the case in US? Probably that deserves another discussion. I couldn't directly answer this question for now, but I think there's another side for the. I'm trying to remind my European colleagues. I think European colleagues, while we are thinking about the best of the tech companies, we also need to think about why Europe hasn't, promoted a lot of innovations, digital innovation, as much as it could be. And I don't think it's just about the US big tech companies. So I couldn't answer the question, but I think it's that the world is so complicated. It's there's multiple sides of this. Let me think probably a couple of minutes. Anyway, I couldn't answer this well now.
Yeah, if I continue a little bit on this Europe thing, I think one has to realize Europe is not one country. You know, that's we keep thinking about it as if it's one country, and actually the service market in general is very poor. Yeah. And you know, I think that's really prevented to some extent these big platforms, but it's not the only reason, I think, but that's always important to keep in mind. But the other thing I want to say, isn't it, and people will know better than me, whenever the US has gone after this monopoly, so to speak, or excess market power, by the time that has been litigated, the power has gone. And so it's sort of, are we too anxious to do something right now, as opposed to, wait a little while and see? I mean, after all, Amazon, for instance, clearly is losing some of its grip in cloud computing and elsewhere, if I've understood it correctly. So this is not a stagnant situation in any sense. We haven't locked in to anything. So it's not like the US doesn't have dynamic. It just seems that China has gotten off to a faster start.
Right. So I echo that point, because in China, you don't need to wait to see the dominance, and it's just very hard to hold it. I think there's a lot of new models, and it's very hard to ward off the new competition. And that's what we in China the companies experience, and in the US, I think also the companies are facing, and probably as you mentioned, it's just a slower dynamic. I don't know, but in other areas it's happening.
Mike, Jacob, you seem to have a suggestion. Mike, are you there?
Oh, if you're speaking about me, Michael Jacobidis, I see Tommaso has his hand. Basically, what I was saying is that there is a rather clear difference between what we see in terms of market reaction for what the announcements are in terms of antitrust, but I would cede to Tommaso to explain what the policy capture issues are. I think that the problem is that we have to consider what is the arsenal in terms of the current rules, and that's been the big question about the ex ante versus ex post rules, and also in particular whether we should be focusing on things that can have dramatic impacts in terms of M&A. So I think that the most realistic way to have a quick impact would be to have a view in terms of M&A. For better and for worse, the institutional structure in China allows for a much tighter, quicker, and less questions asked response when the authorities want to redress issues of that sort. The otherwise sensible checks and balances that may exist in the United States also are open to abuse. And I think that there is a massive amount of policy capture. Let's not forget that big tech is, by a long shot, the biggest both campaign contributors currently in the United States. And also, to put it in the words of an analyst, the kombucha budget of Google is probably...
Oh, I'm sorry. Michael, are you still there?
Oh, sorry, I might have muted myself, and I was saying that the other problem that exists is that we have an issue of the disparity in terms of what the authorities can do and even the resources that they have, which is why I think that those who have served or at least my understanding and recently speaking with them, would lament the huge discrepancy, to put it in the words of an analyst that covers technology. The kombucha budget of Google is bigger than the budget of the part of the regulatory agency in the European Union that needs to cover it.
Thank you, Michael. Tommaso?
Thanks. A couple of reactions. So first, I think I disagree with Bengt Holmström when he says that shall we not wait and see in the United States. In the United States, basically, there has been wait and see for almost 3 decades. We're talking about, and still now, so this perspective that everything is changing at a rapid pace is not a correct description of reality. Sure, there has been a change in leadership at the FTC and the DOJ on running cases, but the new statutory powers that the US Congress was about to legislate once again are not happening because the lobbying activities, this was something that was almost a bipartisan support for it, but it's not happening because it's been halted. It's not going to pass under this legislature. So it's, I don't know, we're still talking about theory. In practice, the United States has not adopted some tools that other countries have adopted. And I want to relate something that people should think about. The evidence we have on dynamism, which has been reduced, generally speaking, in the economy, is particularly true in the digital economy. So the work of Eckhout and De Lurker and others do show that venture capital is exiting from industries which are monopolized. So we have to be very careful saying everything goes fine, there's going to be a reversal of fortune soon. That's what we've done for 25 years. So perhaps experimenting with something else would be the right way to do. On China, I'm not an expert. There's people who know much more. But my really 2 cents on this is that China, there is an economic dimension and a political dimension. Huge fortunes were being created in China that were not acceptable for the Communist Party. So Jacques was becoming just too powerful. When he wanted to expand into the financial sector, etc., the Communist Party halted him. Okay, that was clear. And I think there is a sort of double coincidence of ones. China realized earlier than anyone else that monopolization is not good for investment and for innovation. That's arrow. It's not a big thing. So the monopolized markets innovate less. China does rely on Darwinian competition, but you need to have some competition. So they enacted legislation earlier than anyone else. So China is already 2 years down the line that they have a digital regulation in place. They're not talking about it. They've already been enacted and enforced. And at the same time, this is also tackling the problem of the Jacques and the super rich people that would challenge the the Communist Party. So you know, how do you say in English? You get two pigeons with one stone, or something like this. And this is what's happening in China, in my opinion.
Thank you, Tommaso. Robert Johnson.
Yeah, I wanted to congratulate the Luohan Academy. This is an extraordinary conversation. It does give what you might call tangible testimony to the value of these digital platforms, but the deep complexities, particularly related to the political economy and the role of money as a refractory influence, whether in the media or legislative, regulatory enforcement, or even the nature of what experts feel is taboo, is an important thing to explore and investigate at this time. But I really, really have learned a lot today, and I've enjoyed the quality and the vitality of this conversation. So congratulations and thank you all.
Thank you, Robert. I think we probably have to close the conversation here. Of course, the discussion will go beyond the event. I hope the presentation and discussion here have jogged people's mind. We'll continue discussing these very important questions. Thank you all for participating, and thank Luohan Academy for organizing this event. Thank you.
Thank you all. Thank you, Ginger.
Thank you.
Thank you, everyone.
Thanks, folks, for organizing.
Bye.
Thanks very much.
Bye.
Thank you for attending this.